Today we intend to cover the classification of law, the difference between law and morality, the Constitution, and if time allows us, we'll also cover legislation and its delegated legislation. As you continue to learn, Chapter 2 will be on administrative law, which we will cover the meaning, the sources, and the functions. We'll also cover the doctrine of separation of powers. We will cover delegated legislation, the discretion and judicial count of executive. We'll cover the liability of state, the principles of natural justice, the judicial control of the executive, the independence of the judiciary, the remedies in administrative law, which are mandamus, certiorari, prohibition, habeas corpus, injunction, and declaration. Chapter 3, we will cover the court system, which entails the establishment, structure, composition, and the jurisdiction of courts, the Court of Appeal, the Supreme Court, the High Court, Employment and Labor Relations Court, Environmental and Land Court, International Court of Justice, Magistrates Court, Court Martial, Cathy's Court, and the distinction between courts and tribunals. Having covered the court system, we will go through the alternative dispute resolutions, what its nature is, the types of disputes, the legal framework that governs ADR, the general principles of ADR, negation and conciliation, mediation, arbitration, dispute review boards, traditional dispute resolution mechanisms. Having covered that, we'll go and cover the law of persons, natural and artificial persons, nationality, citizenship, and domicile, unincorporated and incorporated associations, as well as cooperative societies. Once we are done with the law of persons, we'll cover the law of tort, what its nature is, the general defenses, negligence, the types of liabilities in tort, what trespass is, the limitation and survival of actions, the remedies in tort, the principles in award damages, defamation. Once we are done with that, we will go to the law of contract. The law of contract will cover the definition of a contract, the classifications of contracts, the essentials of a valid contract, the terms of a contract, the exemption clauses, the vitiating factors, the discharge of a contract, the remedies for breach of a contract, limitation of actions, contract negotiations, and ICT and the law of contract. In Chapter 8, we will cover the sale of goods, and this will entail the nature and contract of sale of goods, the types of goods, the formalities of the contract, the terms of the contract, the implied terms by statute, by custom or usage, the rights and duties of the parties, remedies for price and breach of contract, the auction sales, the international contracts of sale, FAS, FOB, and all those listed. We'll also cover agency, its meaning and nature, the type of agent, the parties to the agency relationship, the creation of agency, authority of an agent, the rights and duties of the parties, personal liability of agents, the liability of the parties, as well as the termination of agency. In partnerships, we'll cover the nature of partnerships, the registration process and requirements of partnership business, the types of partnerships, the rights, duties, and liabilities of existing, incoming, and minor partners, the management of partnerships, the dissolution of partnerships and its consequences. In Chapter 11, we will cover indemnity and guarantees. This will include the essential features of indemnity, nature and extent of liability of indemnifier, the commencement of liability of indemnifier, nature of the contracts, that is the essential features of the contract guarantee, the distinction between contract of guarantee, indemnity, extent of nature and surety, the obligations of surety, discharge of surety, letters of credit, rights and duties of the parties, termination of the contract, and remedies for breach of contract. In Chapter 12, we will cover insurance. That is the nature of the contract, the type, the parties to the negotiable instrument, the formalities of the contract, the types of risks, parties to the contract of insurance. We'll cover the principles of insurance as well as the types of insurance, transfers and amalgamation, termination of the contract, ICT and insurance. We will cover negotiable instruments, its nature, characteristics, its types, the obligations of the parties, the banker-customer relationship, the presentment, the discharge from liability, the modes of discharge, the dishonor, mode of dishonor, nature of protest, penalties for dishonor, acceptance, criminal liability. Once we are done with that, we will cover the law of property, its definition, its classification, property in land, interest in land. We'll cover intellectual property. We'll also cover the administration and management of land, what sectional properties are, the management company, the obligations of the lessor and lessee in Sectional Properties Act, transfer of land rights, as well as the role of professionals in these land transactions. Once we are done with that, we will move to corporate governance, where we'll cover the introduction, the definition, the principles, the best practice, the role of stakeholders, conflict of interest, compliance obligations, legal audit, that is the definition and objects. Finally, we will cover professional ethics, the introduction and overview of professional ethics, professional misconduct, publicity and advertisement, morality and etiquette, professional ethics for accountants and corporate secretaries, ethics and practice within a firm, and the enforcement of professional ethics and standards. Having gone through the syllabus and having gone through the meaning of law, the nature of law, and the purpose of law, today we'd like to move on with our lesson and cover the other areas. We'll start this lesson with the nature of law. The nature of law has 4 theories. These are the natural law theory. The natural law theory asserts that laws are immanent in nature, to which enacted laws should correspond as closely as possible. This is basically saying that an unjust law is not a true law, in which unjust is defined as contrary to natural law. This, in essence, says that the laws that are formulated should be as close as possible to what the people being governed relate to that as being just. It should correspond as closely as possible to what people believe to be true. This will make sure that the laws that are enacted are easy to follow. Once you believe something to be just, you will not be forced or compelled to follow that. Case in point, you shall not, killing is a criminal offense. We ascribe to that one should not harm another. In such a view, that is as close to us seeing that it would be unjust for you to kill or to commit a crime against a fellow human being. Second is legal positivism. So this is the view that law is defined by the social rules or practices that identify certain norms as law. Law is made for man, not man for law. That is why we are able to amend laws that seem to not work for the good of man. We also have legal realism. Legal realism, law should be understood as being determined by the actual practices of courts, rather than the rules and doctrines in statutes. We need to see its realistic nature. You can't just read law. You need to be able to see it in practice. And the actual practices of court, when you are fined today, you pay that fine. It's not just in practice that you can be fined. It's actually a reality. You'll even be given a receipt that you have committed these, you have gone against the law. Once you have gone against the law, what are the remedies? You will be fined. So we need to see it in reality, and that is legal realism. Then lastly, we have legal interpretivism, that law is not based entirely on social facts, but also includes morally the best justification for the institutional facts and practices that we regard as legal. We just don't do things because they're morally right to do. We do things because there's a legal backing. There is a law in place. In our previous class, we had talked about what are characteristics of law, that it is written down, that it is done, it is continuous. So when we go to legal interpretivism, it means that law which is written down can be read out and interpreted in the day-to-day. It's not far-fetched. It's not something that you hear of. It's a fact. It is something that is happening today. That there are laws that protect people against intruders, that there are laws that protect the land, that they keep us safe, that we are able to hold rallies. It has been interpreted in court that you have a right to freedom of speech. It's not just on paper, it's a reality. Once we are done with that, we'll go to the classification of law. And we can classify law as written and unwritten. What is written law? The Constitution of Kenya is written. It has been published. It is available in both digital form as well as the hard copy. What is unwritten law? Customary law is unwritten. It was passed on by word of mouth. The elders were taught, and they taught the incoming generation. it is not found on, it's not based on anything that is tangible, that there is a first draft, there's literally no draft. It is what was passed on, and it is different for different cultures, different form for different countries as well. What their beliefs were, they're passed on generation to generation. What do we also have? We also have the municipal, we have that classification, municipal national law. Municipal laws are laws that are, in our case, we will talk about counties. What may be recently in Nairobi County, they passed a law that if you're caught urinating on the sidewalks, you will be taken to clean morgues. That is a law they passed. It may not apply in Kiambu County or Murang'a County. It's unique to that particular county. But what are national laws? National laws, they are relations between citizens. National laws are relations between us, regardless of which county you're in, regardless of maybe which city you are in, as long as you're in Kenya, there are laws that bind us together between the citizens and the state, and they originate from parliament, from customary, from religious practices, that we are allowed to congregate on Sundays. For us as a country, Sunday is set aside, both Saturday and Sunday are set aside as weekends. No more, there are no office hours between these two. So these are laws that govern us in aspects of religion. We talk about international law. These are between countries and states and other international persons. For example, the United Nations. They originate from treaties and conventions. We as Kenya are part of the COMESA trade bloc. We have laws that govern how we trade with other countries in that trade bloc. We're also part of the African Union. There are laws that govern our relationship with other states in that union. We're part of the United Nations. We host them at Gigiri. There are laws and treaties that have been ratified in Kenya that enable us to relate with other countries. It's not just within our borders, it's across the borders. Another classification of law is between public and private. What is a public law? Public law is that in which the state has a direct interest. It's concerned with the constitution. And public law includes criminal law, constitutional law, and administrative law. The sovereign, Kenya as a country, is interested in ensuring that the law system works, that we have prisons, we have a civil court whereby if someone wrongs you and it is not a criminal offense, you have restitution, you can take them to court. So what does public law do? Public law asserts state sovereignty. You cannot go against what is stated as public law and escape from the repercussions. We talk about constitutional law. That is public law. You see, the constitution was passed by Kenyans. You went and voted for the 2010 constitution. It affirms that the people of Kenya chose. So the country of Kenya protects that sovereignty that was given by the constitution. We talk about private law. Private law is what governs our relations as people. That if I want to buy a car from you, we will enter into a contract. The contract will state the terms of the transaction, how much money I should pay, how should you deliver the car, is the car registered, is it yours, do you have the capacity to transact that, to transfer that land, or to transfer that car, sorry, does the car exist, or are you selling me something that is not in existence? Private law also deals with land, sale of land. I have identified a parcel of land. I would like to purchase the land from you. So how do we go about that? We enter into a sale agreement. We go confirm the ownership. That is private law. It's also about law of succession, whereby you can write a will that upon my demise, this property shall be distributed this way, that my firstborn child will inherit that land, my second-born child will inherit my car, my nephew will inherit my shares. That is private law. It's also about law of torts and law of marriage. All these are covered in private law. In the classification of law, we also have substantive and procedural. So what is substantive law? It consists of the rules themselves, and it defines the rights and duties to the parties, and the remedies are applicable. Substantive law defines offenses and prescribes the punishment. Case in point is the penal code. The penal code is what is used, is what is mentioned in a charge sheet. If right now someone is arrested and taken to the police station, a charge sheet will be drawn. You cannot be charged with something that does not exist in the penal code. It guides the criminal law system. It also provides the remedies that if you are found breaking and entering, what are what is the term set out? Is it 7 years? Is it 10 years? It provides the remedies that are there. Is that offense punishable by a fine? And as you go to court, the charge sheet will be presented, whereupon you will answer whether you agree or not. But it's written down. You cannot be charged with something out of the air. That is substantive law. It's also the law of contract. It provides the remedies to what we have agreed, that if I don't pay the money that is due to you, having taken your car and having taken possession of your car, what are the remedies available to you? You will go either because I have destroyed the car, then you'll take me to court that I restore you to the position you would have been had I not interfered with that possession of your car. That is substantive law. It provides the offenses and prescribes the punishment. That if you steal, are you stealing as a servant? Or who are you stealing as? And if you're stealing as a servant, how many years can you be taken to court? Will you be able to pay the fine? If not, what happens? That is substantive law. Procedural law is adjectival law. What does this mean? It gives the steps or the principles, guiding principles to be complied with in the administration of justice or in the application of substantive law. Procedural law gives the steps to be followed so that substantive law can come into effect. An example is the Civil Procedure Code or the Criminal Procedure Code. It provides the steps that once you have been found in a place where you have no business being, or someone has gone to report you to the police station, or I have taken your car. What are the procedures? What do you do when you find yourself wronged or in the wrong. Law is procedural. That should that happen, step 1, go report. Step 2, go to court. Step 3, the right to be heard. Step 4, a judgment. So it provides, procedural law also provides the documents that you would need to present in court. It gives you the guidelines that you cannot just appear. You will need to file a motion, either through a certificate of urgency. Then you will file your, if it's the plaintiff, you will file what you want to present to court. It gives you the procedure on how the substantive law will be done, how to approach the court, how to approach once the court process is done, how to get your remedies. It gives you how the steps, step by step, from point A to point B. Like in the case of succession, it gives you the procedure. Where do you start? You start with the local chief, you go to court, you fill the forms, you get indemnities. All these are stated in procedural law. Another classification of law is criminal and civil law. Criminal law is where there's a crime occurs, an act or omission committed or omitted in violation of a public law. The key difference between criminal and civil is that for something to be considered a crime, it must be against public law. Civil is against private law. And criminal cases are prosecuted by the state, whereby the state, through the police, is the instigation of the complainant, whereby you're taken to court, the case is heard, and the sentence may take the form of imprisonment, fine, all these things. So civil law is concerned with the rights and duties of persons, either individuals or corporations, because corporations are legal entities by themselves. So branches of civil law are contract, torts, property, marriage, succession. So what are the causes of action in a civil case? There's the breach of contract, that you promised to deliver a car, you never deliver that car. That you promised to pay for that car, you never paid for that car. That you entered into an agreement to purchase land, but you are not able to deliver the original title. The contract has been breached. You did not live up to your expectations. You did not live up to the terms of our agreement. That is a breach of contract. Defamation. We have had these cases whereby, and currently, even when you insult someone through your mobile phone, you're liable. You will not get away with that. There's assault. There's negligence. What happens in negligence is whereby you're supposed to do something that you don't do. You have a construction site. Ideally, you should cover your construction site so that the falling debris does not harm passers-by. So when you fail to cover and a falling stone hurts a passerby, you'll be taken to court. Or when you're doing that construction and you leave manholes uncovered, someone falls inside, you have caused harm and injury to someone else. So those are the classifications of law that we have covered today. And the differences between a civil wrong and crime. A civil wrong is against another individual. A crime is against the state. And the type of punishment for civil wrongs is basically for the crime, you'll be subjected to imprisonment or fines. But for civil wrong, the compensation is normally financial for injuries or damages. When you're taken to court, you have sent me an SMS that insults me or defames me. I will take you to court and you will be liable to pay me a certain amount of money to cover the shame you have put me through. But in civil wrongs, the burden of proof may shift to the defendant, whereby you're the one to say you did not do what you did. But in criminal law, the state must prove. If you're the one accused, it's the state to prove beyond reasonable doubt that you did that which you have been accused of doing. For civil law, I do not need to go beyond reasonable doubt. I just need to provide evidence on a balance of probabilities that your actions have denied me the chance to fully enjoy my right to go outside and walk in public because you have talked to the public, you have talked ill about me to the public. So those are the differences between the classifications of law.